Good morning, everyone. I'd like to welcome you to our 2021 Virtual Elder Law Day Summer Series. My name is Christy McKenzie. I'm the Assistant Coordinator of Neighborhood Services in the Department of Senior Services of Erie County. This series will be taking place every Tuesday and Wednesday at 10 a.m., including a variety of topics throughout the summer. I would also like to take a minute to thank those individuals who have helped to make this summer series possible, including our County Executive Mark Poloncarz, Kara Nicholson, the Center for Elder Law and Justice CEO, and our Senior Services Commissioner, David Shank. This program will be recorded and available on YouTube shortly. If you have any questions, we ask that you enter them in the question and answer panel. Please refrain from sharing any personal information. I would like to introduce our guest speaker, Kelly Gusmano. Kelly is an associate at Woods, Oviatt, Gilman in their Family Wealth and Estate Planning Department. She concentrates her practice in the areas of elder law, long-term care planning, and Medicaid. Ms. Gusmano is a member of the National Association of Elder Law Attorneys. Welcome, Kelly.
Thank you very much. Thank you for having me today. I'm excited to be able to present to everybody again. I was hoping this year it would be in person, but that's just not to be quite yet. Perhaps next year we'll be able to meet face to face again. So today I'm going to be speaking about asset protection planning, which is mainly geared for planning in the event of long-term care needs, which can be, as some of you may know, very expensive. I like to say insanely expensive, to use that kind of phrase without it sounding too much of an exaggeration. But you know, it's quite expensive and can certainly change an estate plan that's already been set up, and we have to kind of react from there. So what I want you to take away from our session today is that even if there has been no prior planning, and we'll discuss some of those techniques, there's still a lot you can do to protect assets, even if you are about to enter into a nursing home or about to apply for a different type of Medicaid that pays for care at home. So I have our slideshow today. I'm going to ask Christine to go through the slides as I talk and kind of go along the presentation. If anybody has questions at any point in time, feel free to send them along and I'll be happy to stop where I'm at and answer your questions before moving on. Okay, Christine, go ahead to the first slide. So in the broader discussion as we move forward to long-term care planning, is an imperative that everybody have a few of these documents set up in place. Everybody should have a last will and testament. It should be kind of the guiding force behind all of our, not only estate plans, but when we talk about asset protection planning, we're always going to be looking back to the will. We may be shifting assets around in order to qualify for different benefits that will cover those long-term care needs, but we're going to ultimately be following what the will says and what your goals are for where you ultimately want your assets to end up. That's overall, I think, the guiding force behind preserving assets. You either want to save them for your future needs, of course, or you may want to save them to leave to a future generation. So that should be spelled out and laid out in your last will and testament. Everybody should also have a durable power of attorney. And this was actually just updated. Instead of saying with a statutory gifts rider, this should actually say with gifting authority. So we want to make sure that you have appointed somebody else with the financial and legal authority to carry out your wishes if you become unable to carry those out for yourself. The power of attorney just recently changed in June of 2021. Powers of attorney that were executed prior to that are still good, so you don't need to run out and make new ones if you have a power of attorney already. But going forward, there's not going to be that separate gifts rider granting this extra authority. It's going to be in the document itself. We want to be sure that somebody has the authority to move your accounts as needed to help you qualify for benefits if and when the time comes and you're unable to do so for yourself. Of course, everybody should also have a living will and healthcare proxy. That's a statement of your wishes with regard to your healthcare. Those documents are certainly very important. If you become unable to make decisions for yourself, the doctors are going to turn to who you've named in your healthcare proxy. And you should lay out what your wishes are in your living will, just so that your agents know ahead of time And certainly if you would like to do something such as withdrawal life-sustaining treatment, that should be in your living will to provide guidance, of course, but also to provide a sense to your agents that they're not withdrawing treatment that you would have otherwise wanted. There's a certain guilt factor there that we, of course, want to relieve them of if they're just simply carrying out your wishes. And with all of those forms in place, the last thing we always check is to make sure that your beneficiary designations match your overall estate plan. It's no use if your will says, I want everything to go to my kids, but your beneficiary designation says, I want everything to go to my sister. In that case, everything in any account that names the sister as a beneficiary is going to go to the sister. It doesn't matter what the will says, the beneficiary designation will be the controlling document in that case. The will only controls things that are left in your name alone, with no joint owner or no beneficiary. Of course, you may want that account to go to your sister, but we just want to take a peek, make sure everything's updated to reflect the reality of your situation as it is now, and perhaps not as it was in the past when you didn't have any kids or a spouse or anything like that. So we're going to update those documents as well. So with that plan in place, we're going to talk about how things may change. Christine, could you please go to the next slide? Thank you. So we may have executed your documents, we're all set to go. However, you or a spouse, and in this circumstances, we're mostly going to be talking about, if you as an individual are going into a nursing home, of course, these are things you want to think about too if you have parents going into a nursing home, siblings going into a nursing home, or needing care at home. So if this were you and we have your estate plan set up and you or your spouse go into a nursing home, we're going to want to shift everything around. So we've now made beneficiary designations on certain accounts, but we now might have to move those accounts over. So it's, of course, kind of an ever-changing process, but your will and your estate plan, as we've laid out in those documents, is going to be kind of the guiding force to make sure after we move things around, your wishes are still carried out. Nursing home care is one of the things that really can deplete your life savings. Of course, we worry about other areas where you're open to liability. There's insurance coverage for that. There's also insurance coverage for long-term care, but not everybody has it, and it's also very expensive. But if you're spending money at the nursing home or in assisted living facilities or on in-home aids, it can substantially deplete your savings and alter that estate plan. Where you thought you could leave everything to your children upon your passing, you might end up having to spend everything to a nursing home before that happens. And your money should be there to take care of you, of course, but I have yet to meet a person that would rather the nursing home get all the money rather than their children, if their care can be provided for through other means. Okay, go ahead, Christine. So nursing homes currently, depending on where you live, can range anywhere from $12,000 to $17,000 per month. Where I am sitting right now here in Rochester, where they're typically more on the higher end, we do have nursing homes that charge $17,000 per month. There's also certain programs that charge higher than that if we need certain behavioral care. So you could expect something more in the $20,000 range per month. Over in Erie County, where we also have an office in Buffalo, and I'm over there sometimes, the nursing homes tend to be a little bit on the cheaper side, but that's all relative at this point. Cheaper just means a few $1,000s less, but we're still talking about $12,000, $13,000, $14,000, which, as you can see, that adds up very quickly. All right, let's switch to the next slide. So, of course, the question is, how do we pay for all of this? You shouldn't deplete your life savings. There are options. The good news is, if you haven't purchased long-term care insurance, if you haven't done any prior planning, there's options for you. So let's talk about what those options are. Go ahead. There are different ways you can pay for that nursing home care. Now, it may be that you only need a rehabilitation stay, something that's short-term. Medicare will often cover rehab at a skilled nursing facility. Now, the Medicare benefit is limited. It will pay up to 100 days. The first 20 days are typically covered in full by Medicare. days 21 through 100 are covered with a copay in most instances, which is currently right around 170 a day for days 21 to 100. Some individuals have supplemental insurance that will also pick up that copay so that for the first 100 days, they don't have to pay anything. The kind of scary news, the caveat to all of that is that Medicare at any point in time can decide that you do not need rehab coverage or rehab services any longer, that you're not benefiting from the services or you don't have a continued need for that type of skilled rehabilitation. And Medicare can say, okay, 3 days from now, we're going to cut off your coverage. So you can have about that much notice before you're on the hook for $300, $400, $500 a day. Okay. At the private pay rate, if we're spending about $15,000 a month, it can be upwards of $180,000 per year. So the faster you do something, the better. There's a lot of techniques that we'll talk about that can make sure that we don't go through that $180,000. If you have long-term care insurance, fantastic. That always helps. It always increases our options. Long-term care insurance can be very expensive, so not everybody does have it. And if you do have it, it might not cover the full private pay rate. We might have $500 per day for a certain room that we're in a nursing home, and perhaps the long-term care insurance covers $300 a day. This will end up in a large shortfall over a large period of time. Hopefully there's other income to provide the coverage for that gap, to kind of afford that gap while you're at the nursing home, but maybe not. In that instance, we're going to look towards Medicaid to pay for your care. And now people tend to get the wrong impression when it comes to Medicaid. And Christine, you can move to the next slide. A lot of people believe that Medicaid is purely for poor people, to put it quite frankly. However, Medicaid is there as just another insurance coverage. Everybody who has Medicare, who is deemed disabled over 65 or blind is eligible for this type of coverage, assuming that their resources also meet the limits that entitle them to this care. Now, the benefit of Medicaid, if we can access that coverage, is that it will ultimately bring your private pay bill from $15,000, $17,000 a month down to the amount of your monthly income, or perhaps the amount of the couple's money might be set aside for a spouse too. But in C, if your bill now is maybe $1,000, $2,000, $3,000 a month and is affordable with your income, you can afford the nursing home kind of the rest of your nursing home bill up to their kind of Medicaid for your care going forward. Go ahead, Christine, next slide. So Medicaid has the restrictions that we talked about before. You have to be deemed disabled, you have to be over 65, and you have to be or blind in order to qualify for this type of Medicaid that we're going to talk about today. There is another type of Medicaid that is based purely off of your adjusted gross income. We're not going to be talking about that today. There are certain nursing home benefits for that, but the income is so limited that most of the individuals that we work with just purely don't qualify. So we're going to focus today on the Medicaid that you can get once you're over 65. That's typically what we run into. The bad news, or at first blush, you may think, okay, I'm not eligible. I see right here, it says there's a resource limit of $15,900. Now, what that includes is bank accounts, stocks, bonds, mutual funds, the cash value of life insurance, and any other non-qualified investments that you might have. The good news is that a house and any adjoining land with that house is exempt. Life estates are exempt. One vehicle is exempt, and retirement funds are exempt. There's a slight caveat to that because we do count those required minimum distributions that come from that retirement account as part of your income, which is ultimately going to be paid over to the nursing home, but the principal balance in the account is exempt. So you could theoretically have less than $15,900 in countable resources, that first kind of group of resources up there that we're going to count towards your total. And you could also have $1 million in your IRA and you could qualify for care. So it's very beneficial that the retirement funds don't count. That is not true in every state, but certainly true for New York. So we're lucky in that regard. Also, a prepaid burial account is exempt. So we often recommend that that be funded as well as part of our overall Medicaid planning. Now, there's no strict income limit when it comes to Medicaid, unless your income is above the private pay rate at the nursing home. Hopefully you wouldn't need Medicaid in that instance, but you purely just won't qualify because you won't have the medical bills to kind of offset your income. So the amount that you pay to the nursing home is going to be based off of your income, whatever it happens to be. Okay. So if you have $3,000 in income, Medicaid says, okay, we'll pay for the majority of your care, but each month that goes by, you're also going to have to contribute. So that $3,000 that you have in monthly income, whether it be comprised of Social Security, pensions, retirement funds, or any other sources of income, you keep $50 and the rest has to go to the nursing home. Now, again, there are some benefits for the community spouse, somebody who's living outside of the nursing home, and we'll talk about what those are. They may get to keep some of that monthly income, so then they aren't left with no funds to just provide for their daily living expenses outside of the nursing home. Okay, let's move on to the next slide. Whenever we're evaluating whether or not somebody's eligible for Medicaid, we go through kind of a few different criteria. One, do they fit into that overall category of people eligible for Medicaid based off of the three things we talk about: over 65, disabled, or blind? Do they fit into that category? The second one is, do they qualify based on their resources? If they don't, what strategies can we use to make them qualify? We'll talk about that. And then the third thing is, did they make any gifts in the prior 5 years that might prevent them from getting coverage? So for every, in Erie County and in Western New York, for every $11,054 that is gifted in the prior 5 years before applying for Medicaid coverage in a nursing home, Medicaid will refuse to cover 1 month of care, meaning that then you have to privately pay. So if we have less than $15,900, we submit an application to the County Department of Social Services and we say, Medicaid, please, we want Medicaid. They're going to say, did you give any gifts away in the last 5 years? Under the theory that if you gave away money that could have been used to provide for your care, we as Medicaid, as taxpayers, and as this fund that provides coverage for individuals, is not going to provide for your care. So we could end up with a period during which Medicaid coverage is unavailable for certain individuals. Again, however, we do look through the financial history for our clients to determine whether or not there have been any gifts in the last 5 years, and if so, what we can do to perhaps plan around those penalties if we're going to get a penalty, or cure any penalties. For instance, perhaps the transfer was made to a disabled child. Well, the good news is that's actually an exempt transfer. There's no penalty whatsoever for that. Now, I do have a question that just came through. Let me see if I can pull it up. Does the same gift limit apply when two spouses are gifting? Yes, it's the same divisor. So every region in New York has this divisor rate where they say for every X amount of dollars, Medicaid refuses to pay for 1 month of care. When there's a husband and wife applying, it doesn't matter. They're not allowed to gift 22,000 before Medicaid refuses to provide 1 month of care. They're kind of counted together as one entity. So if it's husband or wife doing the gifting, doesn't matter. If let's say the husband's in the nursing home, wife gifted $11,054 in the prior 5 years, husband's not going to get 1 month of nursing home coverage. So they do combine the two of them. With one slight asterisk next to that, if the gifts were made between husband and wife, husband gave wife $11,000, there's no penalty for that. This is purely gifts to other individuals. Again, disabled child doesn't count. There's certain other ways we can gift assets that don't incur a penalty. Um, those are unfortunately few and far between, but there's other things we can do to still get the Medicaid. Okay. And I just want to emphasize that it's never too late to engage in strategies. If there has been gifting in the past, let's figure it out now so that you don't end up in a situation where you run out of money. Then you apply for Medicaid and oops, now Medicaid sees that you did some gifting in the past. You're not going to be able to afford your care. The nursing home's not going to get paid because Medicaid's not going to pay for your care, and you can end up in a really sticky situation. So, if there are prior gifts, let's talk about things we can do. If there are no prior gifts, let's talk about ways to get Medicaid and still protect assets, and that's obviously what we're getting to now. So Christine, go ahead on to the next slide. So when you come to us, the ultimate strategy depends on everything we've talked about, of course, but now we've kind of reached a bifurcation. We have different strategies available to us if there is a spouse living in the community. So in other words, is the Medicaid applicant married? If so, great, we're going to go one direction with you to preserve assets for the community spouse and for ultimately whoever you want to inherit your assets. Obviously, we want to put that kind of money aside. We're going to go a different direction if the Medicaid applicant is a single. We're going to do what we call a gift and note plan or a gift and loan plan. This is another way we can protect assets and apply for Medicaid. So I'll walk us through these two different scenarios or these two ultimate plans for what we can do on the eve of somebody going into a nursing home, even if we've not protected any money in the past. All right, you can go ahead on to the next slide. So let's start with a situation where we have, we said that there was a husband before as the Medicaid applicant. So let's just stick with that. He's what's called in the Medicaid world, the institutionalized spouse. In other words, the Medicaid applicant. So we know that his resources need to be below $15,900 in order for him to qualify for Medicaid. So the wife comes to us, she says, my husband needs Medicaid care. They're saying the nursing home's going to cost us $15,000 a month. What do? We don't qualify. Well, I'm going to run them through the scenario. Hopefully Jane is either joint on John's bank accounts, as we have here, or that she's POA for John so that we can do some of this moving of assets around. She would need that gifting authority to kind of move this money. Okay. Here we would say, Jane, we want you to transfer all $100,000 of John's funds to yourself. So she authorizes the transfers as John's POA. She gives that money to herself. John is then left with $0. Obviously, we don't leave him penniless. We can leave him with up to $15,900, but let's keep the math simple for now. We then tell the wife to sign what's called a spousal refusal, which is merely a tool. It sounds unkind, but it's just used so that there's essentially a wall put between John and Jane. John applies for Medicaid, says I have less than $15,900. And my wife is refusing to provide for my care. That forces the Department of Social Services to render a decision as to whether or not John's eligible based on his resources alone. Okay. There's no penalty for him having transferred money to Jane because there's no penalty for transfers between husband and wife, even with the spousal refusal. Now, it sounds kind of too good to be true that we can do this. Now, in some counties, we can execute this type of plan, no problem. The county will say, okay, great, we see you gave all the money over to Jane. John's eligible for Medicaid, go on your merry way. And Jane will never have to worry about contributing toward John's care. That's not true in every county. It's actually not true in most counties. Jane is actually, and let's go to the next slide, Christine. As the community spouse, still living in the community, Jane is actually entitled to her own resource allowance. Now this is a range. It's between 74,820 and currently 130,380. Random figures, of course, it sounds like, but regardless, let's just use 74 as her resource allowance. So if she herself has more than $74,820 and she refuses to provide for John's care, the county can say, hey, we've been paying for John's care. You're technically legally responsible as his wife. We want you to reimburse us for the care that we've paid for John. Now, the good news is, even if they do that, Medicaid has not been paying the full private pay rate for John for all the time that he's been on Medicaid. Medicaid pays what's called the Medicaid reimbursement rate to the county. So we have this chart here showing the private pay rate at about 15 grand. But for an individual who's on Medicaid, the nursing home is only getting about 7 grand. And we've talked about how there's an income contribution each month. Each month that John's been rolling along here on Medicaid under the spousal refusal plan, the county has told him you need to pay $3,000 per month. So in this scenario with the numbers we have, John as the Medicaid patient pays his 3 grand, and then Medicaid comes over the top to pay the remainder of 3,500 to make sure that the nursing home gets that full Medicaid reimbursement rate. So if you're in a county that does seek that spousal support or reimbursement from the spouse, you can think of it as that they're only going to be able to collect 3,500 from Jane for each month that he's on Medicaid. So even if they do go after the spouse, we still got the ultimate nursing home bill down from $15,000 a month to $6,500 a month. So there's still significant savings. It's great if you're in a county that doesn't go after the spouse, but it's still significantly cheaper than privately paying to do it this way. Additionally, the higher the income of the Medicaid applicant, the less that Medicaid is going to be able to seek from Jane in this scenario. So let's say John's income is $6,000 a month. Let's say he has a lot in his IRA. It's distributing a fair amount in his required minimum distribution each year. Well, Jane only ever has to worry about the county saying, you owe us $500 for every month that John was on Medicaid. Yes, it's going to be a good chunk, but still significantly lower than $15,000 a month for as long as he's there. So this is always a viable plan that we use very often for husband and wife. I'm going to talk about a tweak to this in just a moment, but I want to pause to discuss how the income is calculated between husband and wife. So the way that it works, or the overall rule, is that Medicaid makes the Medicaid applicant pay over the amount of their monthly income. There are certain deductions for health insurance premiums, such as Medicare, which comes out of Social Security automatically for almost everybody. If you have a supplemental plan, there's a deduction there from your payment to the nursing home. And then Medicaid allows that Medicaid applicant a $50 a month income allowance. This can be used pretty much like for haircuts and maybe a telephone line in the nursing home. Obviously, it's not significant. All of the other income goes to the nursing home, but if there's a community spouse, the rule is slightly different. If the community spouse has less than about $3,000 in monthly income, the figure is technically $3,259.50. Why? It's based off of poverty rates. If they have a less than that magic number, there's a further deduction in the Medicaid applicant's income to allow the spouse enough monthly income so that she has access to $3,200, that 3,000 figure per month. So essentially, John's monthly payment will be reduced so that she can keep some of the couple's monthly combined monthly income. On the flip side of that, if her income is above that magic number of $3,259.50, she is going to be asked by the county to contribute a quarter of her excess income so that John will pay his monthly income to the nursing home, and they'll say, Jane, you have, let's say, $4,000 a month in monthly income. A quarter of that is approximately $250. We want you to add that to John's nursing home payment each month. So that's how kind of the budgeting works between husband and wife. As I said before, income is made up of Social Security, pensions. To the extent that there's retirement funds, the required minimum distribution that is distributed each year, that's going to be calculated on a monthly basis and become part of the monthly payment to the nursing home. So we often have husband and wife say, we know what your RMD is going to be for the year. Tell your financial advisor or contact the company that's holding the plan and tell them to distribute a 12th of that monthly. In other words, make them get the required minimum distribution over the course of the year. So I think I've kind of talked that one to death. Let's just talk about the slight change that's available in the spousal refusal plan that affords a little bit more protection to the community spouse. Christine, you can go to the next slide. We talked before how the community spouse is allowed about $74,820 of his or her own resources. That's her in this scenario, is her resource allowance. Anything over and above that, the county can say, hey, you were supposed to contribute, you need to give us that amount. They can never take more from her though than the $74,820. That's her overall resource allowance. In this scenario, we've gotten pretty much the same place as we did in the spousal refusal plan, but we don't have her sign a spousal refusal. So all of the money goes over to Jane, and anything that she has above her resource allowance of $74,820, she's actually going to loan that over to her daughter or her son. A trusted individual, could even be a sibling. If she loans her excess over to this trusted individual, she no longer has excess income. I'm sorry, excess resources. So no need to sign a spousal refusal. No right is given over to the county for them to seek some support from Jane because she doesn't have excess. Now, this isn't a gift though, because if we did a gift, it would be penalized. It's simply just a loan. Jane is loaning her money to the trusted child. We have that child sign a promissory note where they promise to pay it back to Jane over the course of a number of months. And we have to base the term of the loan over her life expectancy as provided under certain Medicaid tables. So actually, I have them right here. For somebody who is 85, Medicaid says that her life expectancy is 6.95 years. So we're going to pay that money back to Jane over that 6.95 years in monthly installments. Now, this converts the excess resources into a stream of income. So yay, we never leave her open to liability for the county to come back after her. However, when we talk about the payment to the nursing home, it's based upon the couple's income. And now we have given Jane a little bit more income each month. So that might mean the monthly nursing home payment is slightly higher because Jane's income is higher. But again, we're talking all relative here. Nursing home bill, $15,000 privately. With an income stream plan, maybe the nursing home bill is $4,000. If we do a spousal refusal, maybe it's $3,000, but they can seek that support from Jane. So couple different factors to look at here. It might be right for some individuals, not right for others. It's just something that has to be evaluated. It's certainly not something you would do yourself. I mean, these are steps that we would walk through together if you have an elder law attorney that you would walk through together to see which way kind of makes sense for you in your circumstances or for a loved one in their circumstances. So now we're going to flip the script a little bit. Christine, if you want to go to the next slide. So we've talked about how we can go down one route. Oh, I do want to pause here because I have a question. Is there okay, so question for the income stream. I'm going to read it out for everybody. Is there a time frame to give the loan? What I mean is, can I do it at the same time within a month of applying for Medicaid? Yes, there's no time frame. The only time frame is we don't want to do a spousal refusal. We want to make sure we have the income stream note in place so we've eliminated the excess resources by the time we're applying for Medicaid. Now, you don't want to do it before you apply for Medicaid, really. Because if you, let's say, 3 months before you apply for Medicaid, you do this income stream note. And you leave the wife with 74,820. Each month that goes by, this trusted individual is paying money back to Jane. Her resources are going to go back up. So if you then apply for Medicaid, well, she's got more than 74,820 again. So you want to do this when you apply. And actually, the rule is once a spouse is on Medicaid, Jane could literally win the lottery and have $3 million, and her resources are no longer going to affect John's Medicaid eligibility. But that's only once he's on Medicaid. So this is something you do pretty much as you're applying for that Medicaid application or Medicaid coverage. Okay. So switching over to the gift and note or gift and loan plan, we're taking some similar things from the income stream note, but it's obviously different in this scenario. The biggest difference here is that when we have husband and wife, we can take advantage of the fact that the Medicaid applicant, the husband, can transfer everything over to the wife, and the husband can qualify for Medicaid. We do our 5-year look back. There's no gifts because John transferred to Jane. There's no penalty for transfers between spouses. In this scenario, there's no spouse. So one thing we could do if the Medicaid applicant has had a disabled child, we can transfer everything to the disabled child. There's certain ways we might want to do that so we don't affect other benefits, but that would be an example of a transfer that's not penalized. In most cases, however, that's not the circumstances that we're given. So in this case, let's say we have an individual, let's say it's Jane this time. Jane is going into a nursing home and she has $100,000. Again, we know she has to have less than $15,900 in total assets. We have too much. So in this scenario, we're going to get rid of her excess resources by doing two things. We're going to essentially draw a line down the middle. 50 on one side, 50 on the other, 50 grand. It's not always half and half. It depends on how much income Jane has, but in this situation, just for illustration's sake, we're going to say we'll divide it in half. Half of the money, half of the 100 grand, we're going to gift to the beneficiaries that she has kind of provided for in her will, or to one child who then will distribute it according to her wishes. But we're going to gift that money. So that's going to be gone. And this is as we're about to apply for Medicaid application. The other half, the other 50, we again loan to somebody. We loan to a trusted individual. And we tell that person, you need to sign this promissory note and promise to pay it back. Now, if we've gotten rid of 50 and we've gotten rid of 50, Jane has less than $15,900. We apply for Medicaid. And part of the application process, the Department of Social Services is going to say, did you give away any gifts in the last 5 years? And I did have a question come through, and I'll address that one in just a moment because it's very important, but I just want to get through this part. So Medicaid's going to say, did you give away any gifts in the last 5 years? And we're going to say, yep, sure did. We put it right on the application. We say, we gave away $50,000. So they're going to say, okay, so we take that 50,000, divide it by 11,054, and I don't have a calculator and I'm horrible at math. I think that's about 4.5 months. I hope you're not laughing at me. I think it's that. We're going to refuse to pay for your coverage during that period of time. However, as part of our plan, we already know this is going to happen. So we've calculated it so that during that 4.5 months or whatever it is, you have income coming from the loan that you made. So each month that goes by during that penalty, you're going to pay the nursing home your Social Security, your pension, your retirement account, plus a chunk of the money from the loan. And you're going to be able to afford the private pay rate at the nursing home because we've balanced these numbers appropriately so that, let's say your Social Security, pension, retirement account are $3,000. We're going to make sure you're getting 12 grand from the loan for those 4 months. I know the math isn't going to work out here perfectly because we balance these pretty carefully as we go along. So during the penalty, you're going to be paying the full private pay rate. We're in that penalty period. We made the gift. However, we have the money coming back in from the loan to pay it. Once you're through the penalty period, once you're through those 4 months or so, Medicaid will then kick in and provide full coverage. And at this point in time, the loan money will also have all been paid back and paid over to the nursing home. So that money that we loan, we ultimately can't protect. It is going to come back and be paid over to the nursing home. But because of that, we can protect the $50,000 that we gifted. This is a strategy that we use for a lot of our single individuals going into a nursing home. We call it a gift and note plan or gift and loan plan. The more income you have, the less we need to loan because I need you to be able to afford the private pay rate at the nursing home during the penalty. If your income's high, you don't need as much in the loan, which means that the loan can be smaller and the gift can be larger. On the flip side, if your income's very low, I need my loan to be larger to compensate for the gift. So, roughly speaking, we can protect about half of the assets when somebody goes into a nursing home, even if you've done no prior planning. And when I say half of the assets, I'm talking about half of the countable assets. Again, that doesn't include the house, it doesn't include a car, it doesn't include a retirement fund. Although, going to be huge kind of bold letters right here. At this stage, you can get Medicaid if you have a house. And I think this is going to be getting into the question I had. Let me just pull that up here. The question is, can Medicaid put a lien on the house? Yes. So at this stage, let's say Jane had $100,000 plus a house. So long as Jane has an intent to return home, if she's in a nursing home, whether or not she actually can, as long as she utters kind of the magic phrase intent to return home, and tells the county that, yep, if I were able to, I would return home. The house is exempt at this stage. So she can get on Medicaid. It won't count as an asset, making her over $15,900. But the county is permitted to put a lien on the house. But eventually, when Jane passes away, the county can collect from the sale proceeds. So this is something that we evaluate as part of the overall plan. The house is technically not a countable resource, but we might want to, for our purposes, treat it as a countable resource so that we can also protect the value of the house. Now, how can we do that? We can transfer it perhaps to what's called a caregiver child. If there's a child that lives in the home that's been staying with the Medicaid applicant for at least the past 2 years, the theory being that they're keeping them out of a nursing home because they're providing that care. As long as the child has lived there, Jane could transfer the house to the child without penalty. It protects the house, the resource is exempt, they can't place a lien. So that's one thing we could do that doesn't apply for everybody. Another thing we could do is when we're preserving assets, we can perhaps transfer the house and, sorry, another question came through. We can transfer the house and then offset that with loan funds. So there's another question. Let me pull that up. If the community spouse is living in the house, can a lien still be placed while husband is in a nursing home? So let's go back to our situation where we have Jane and John. No. In that situation, if there's a community spouse living there, a lien cannot be placed on the house. So we don't need to worry about having Jane transfer the house or something like that at that point in time. There are other things that we would want to do. So everything we're talking about is what we should do to protect assets immediately. But there's other things as well. We want to make sure that if somebody passes away, they don't pass away with a ton of money in their estate, or perhaps if the community spouse passes away, they don't leave everything to the spouse in the nursing home. So there's a lot of work too that we have to do on the back end, and I suppose that would be good for another presentation, just to make sure that the plans we put in place aren't sabotaged by, and it's a harsh way to put it, but by assets coming back into their name. Now, we're also concerned about there being money left when a Medicaid applicant or Medicaid recipient passes away, because the county can make a claim on the estate. But again, I don't want to get too off track, because that's a whole other level and kind of adds some confusing things to work through. But I'd be happy to answer any subsequent questions about that, maybe online or with a telephone call. Happy to discuss. So let's move on to the next slide, and I will get to any further questions in just a moment, because I think we're right here at the end, so I'll be happy to answer questions. Basically, have an estate plan in place. That should ultimately be the guiding factor. Not everybody ends up in a nursing home. Not everybody ends up needing in-home care or long-term care. Have everything in place that you need. Also have tools in place so that somebody can change your estate plan if need be, who you know and trust, and who knows what your wishes are, like a power of attorney if we need to make subsequent changes. And just remember too that the options we've discussed today are things you can do even if there's been no prior planning. So there's 2 points I want to make before I get to questions. There is prior planning you can do. So we've talked about the 5-year look back. Well, if you've gifted assets more than 5 years before a nursing home application, great. Those resources are already protected. We don't even need to report them in most cases. That is money that's kind of set aside, protected already. You can do that through just outright transfers to children, or you can do it through trusts. Now, careful thought should be had as to how you protect money in advance. If you don't make it through 5 years, it might be that money has to be returned. Or conversely, we want to make sure we're not transferring stocks, if those might be more appropriate to transfer to a trust, because there's certain benefits that a trust offers tax-wise, so that ultimately we're not losing the value of the asset that you're trying to transfer. And the other point I wanted to make too is we've covered mainly nursing home care. Medicaid does provide coverage for in-home aides. The rules are a lot less strict currently, but that is going to be changing. So for any individual who needs care at home, they can transfer assets right now and qualify for that care without a look back period. I have had individuals who I have somebody right now who's paying $18,000 a month on in-home aides, or transferring money so that they qualify for Medicaid to pay for those aides. So there is care at home. It's easier to get right now, but as of the beginning of next year, unless it gets delayed again, there's also going to be a look back for community Medicaid. Again, that's a whole other presentation in and of itself, but I just want to make people aware that that is a benefit that can be explored to provide assistance at home. So let's go on to the questions. We have a little bit longer here, and I don't mind staying as long as necessary. There's a question that, does a life estate protect the home as an asset? Yes, but not a blanket yes. So if somebody has a life estate in a house, that life estate does not count as an asset. What does perhaps count is the interest that you give to another individual. So let's use some real world examples, or I guess hypothetical. Jane and John, let's say they, more than 5 years ago, they transferred the remainder interest in the house to their daughter. that remainder interest has a value, and it's treated as a transfer of an asset, even though they've retained a life estate. So a life estate, for those of you who are unfamiliar, think about it as kind of putting a beneficiary on a house. The homeowner has the right to live there. It's their house for the rest of their lives. But as soon as they pass away, the house is it belongs to the holder of the remainder interest. That is a good way to transfer assets without giving up the home as an asset during lifetime. So let's say they did that more than 5 years ago. They then apply for Medicaid. They still just have a life estate. Great. That's not going to count as an asset. The transfer was over 5 years ago. They can get Medicaid. They did it 3 years ago. However, there's going to be a penalty because the remainder interest has a value. The value of the remainder interest depends upon the value of the home and the life expectancy of the life estate holders. So it's a tool that can protect a house. Very, very useful tool. We just have to make sure we go about doing it the right way. Another question came through. What is the average cost for estate planning? Every attorney is different. Depends where you go and how complicated your estate plan is. There are some attorneys who charge, goodness, $200 an hour. My billable rate, for those who are curious, is $280 an hour. If we're doing something like wills, powers of attorney, healthcare proxies, somebody described it once as the starter package or something along those lines, you know, those documents everybody should have. You know, a few hundred. It can get more complicated if you have assets here, there, and everywhere, and we need to consolidate them. Or if we talk about asset protection planning, if we're trying to do something in advance, you can expect to pay something like $2,000 to $4,000. If we do trust, it kind of depends on what we're doing. The crisis planning that we've talked about, I just want to put this out there too, so everybody's aware. It can be anywhere between, and I'm giving a broad range here depending on who you go to, and $8,000 to do all the planning to $15,000, $16,000 to do all of the planning. Part of it depends on the attorney, largely depends on what assets you have and what plan we have to put in place to protect them. But granted, this is a small cost to pay in the overall grand scheme of things. It's about the cost of 1 month of care at a nursing home. And then hopefully if we put the plan in place, you're not then paying the nursing home in perpetuity for your care. It's just kind of the one-time cost to protect assets. So it can be costly, of course, but obviously you're spending money to protect almost all of your money or half of your money. The next question is, do you have to hire an attorney in the county you live in? We have somebody who perhaps might move outside Erie County. No, not necessarily. Medicaid is state specific. Of course, it's a federal program too, but it's state specific. Now, every county does treat Medicaid a little bit differently. In as far as that, there are of course rules, but there are small tweaks and changes that are different between the counties about what they require and what they'll kind of look at. You can hire an attorney anywhere in New York State to do your estate plan. Your Medicaid application. They will use the rules that pertain to the county that you live in order to do the planning, because that's ultimately where you would be filing the Medicaid application. But again, the rules are the same statewide, so anybody in the state should be able to handle the application, assuming too that it makes sense for if you have to meet in person, that you don't have to drive across the state to do so. But almost everything can be done in person, over the computer now. I don't see any more questions, I don't think. Thank you all so much. That has been fantastic. I always love presenting at these. If anybody has any questions, my contact information is right here on this slide. I think it will be made available on the website as well. Feel free to give me a call. even if it's just a one-off question that you're curious about, I don't mind being a resource to individuals. If you hire us to do a plan, obviously we'll talk about specifics and costs and things like that at that point in time. But if you're just kind of curious about one or two things, don't hesitate to call. I'd be happy to answer your questions. All right, thank you.
Thank you so much for joining today, Kelly, and providing such a comprehensive presentation and taking time to answer all these great questions.
Oh, you're
Also,
very
for
welcome.
everybody who's joined, there will be a brief survey that will pop up at the end of this, and hopefully you will join us again next week for our topics on stimulus checks backs and issues facing older LGBTQ adults. So we'll see you next week. Thank you again, Kelly.
No problem. Bye. Take care.